Hello, Dr. Michael Arnheim here again. This time I want to talk to you about a particular case which is really quite important, called a shocking case, for a very simple reason, which is that the case involves shock treatment, or what is technically known as electroconvulsive therapy. Now, that is essentially passing a current of electricity through the patient's body, and as you can see from its very name, it's expected that it will cause convulsions. Sounds like a very drastic type of treatment, which indeed I believe it is. But what's it used for? It's used in psychiatry and seems, for some unknown reason, to have some good effects. But it does carry with it some very, very serious dangers. Now, this particular case, which came to the court in 1957, a long time ago, is still a very important case. It's called Bolam against Friern Hospital Management Committee. Bolam and Friern Hospital Management Committee, 1957. Mr. Bolam was suffering from depression. Yes, that's all. And he was a voluntary patient at this mental hospital. He consented to the treatment, the electroconvulsive therapy, shock treatment, without being told of the risks involved. And the treatment was, in fact, conducted without Mr. Bolam being given any relaxant drugs or even being held down on the bed while the electric current was going through his body. Even then, those two ways of administering this treatment were quite common, but the way it was done on Mr. Bolam involved neither of them. He was not given any relaxant drug or any form of anesthesia, which would now be quite normal, and he was also not held down on the bed. As a result, when the current went through his body, he went into convulsions which left him with a bilateral fracture of the pelvis. In other words, his hip was fractured on both sides, bilateral hip fracture, and he arrived in court in a wheelchair in a pitiful state. So if he had anything to be depressed about before the procedure, he certainly had good reason to be depressed afterwards. Now, was the hospital negligent? This is the question. Was the hospital negligent in giving him this treatment and giving it in this particular way? The result was a verdict in favor of the hospital. In other words, the jury said, no, there was no negligence here. Now, why did they say that? Notice it was a jury trial, judge and jury. They said that because they were actually more or less directed to say that by the judge, who put this as the test. A doctor is not guilty of negligence if he has acted in accordance with a practice accepted as proper by a responsible body of medical men skilled in that particular art. A responsible body of medical men. What does that mean exactly? It's a very vague phrase. How large has this body got to be? 2 members? 5? 10? 100? There's no indication. What happened in this case was that the hospital brought a couple of other psychiatrists as witnesses to say that, yes, we would perform the electroconvulsive therapy in exactly the same way as it was done, without relaxant drugs and without holding the patient down on the bed. And the judge said that that meant, therefore, that there was a responsible body of medical men agreeing with the defendant hospital, and the hospital was off the hook. So the jury really had no choice in the matter. And had they been left to their own devices, one suspects they probably would have come out in favor of Mr. Bolam, but they really weren't given that opportunity. Now, that, you might think, cannot possibly still be the law. Unfortunately, you'd be wrong. It is still the law. The Bolam test is still alive and well, although slightly wounded. One aspect of the Bolam test has been rejected and overruled in that respect by a 2015 case in the UK Supreme Court called Montgomery versus Lanarkshire Health Board, a Scottish case. Montgomery and Lanarkshire Health Board, 2015. But that has only overruled one aspect of Bolam, and that is the aspect of informed consent. So, as long as the patient gives informed consent to the treatment, the very same treatment that Mr. Bolam received would still be quite acceptable in legal terms. Informed consent means that the patient has to be told the risks involved, the degree of seriousness of those risks, and the probability of the risks occurring. As long as that is done and the patient still gives consent to the procedure, it can go ahead. So the actual procedure and the way it was done is not necessarily a cause for a finding of negligence. Now, only the question of informed consent would be a problem in that particular case. Otherwise, the result would be the same. So you might think, well, why hasn't the law changed in regard to the actual treatment, not just informed consent? Well, I agree. The law should have changed, and I think the Bolam test should have been overruled completely long ago. Now, I have written about this and other problems in the law in my most recent book called Anglo-American Law, A Comparison. Exhibit A over here, you can see, is quite a hefty book. 500-page book, which is quite expensive to buy in this format, but very inexpensive to buy in Kindle. You see, this format has the advantage of being also a good doorstop, and actually quite a good weapon as well. But the Kindle is a lot cheaper, and I will be talking about other aspects of the law of tort, because that's what this is all about. This particular case is a case of tort, the tort of negligence, and I will talk more about that in future videos. Thank you for listening or watching.